Hi everyone, Hank Abramson here again with Business Beer and IP, that's me, a vlog brought to you by Henry Martin Law. Today I want to quickly talk to you about personal guarantees in leases. What's this all about, and do you have to sign one at all? Why is it even in the document? Why is it buried in the back? Well, you may go and try to lease office space and the landlord hands you the commercial lease. It may be of varying lengths, 10, 20, 30, maybe even 50 or 60 pages. And oftentimes, if you're trying to sign that lease in the name of your corporation or limited liability company or other type of limited liability entity, you'll see a sneaky little document in the back, either as a standalone document or as an exhibit or a schedule or an addendum, something along those lines that's called personal guarantee. What the personal guarantee is saying, usually it asks for you, the business owner, or if there are multiple business owners, then each of the business owners, and sometimes the spouse or spouses of the business owners, and I've seen other related family members be asked to provide the guarantee as well. And basically what the landlord is asking is for you to personally, and or your family members personally, to guarantee those financial obligations that you're signing up for in the lease under the name of the LLC. Now, why would they ask you to do this? Well, if you've seen my other videos on limited liability entities, the main purpose of a limited liability entity is to shield you personally from the business liabilities that you may incur while operating through the business. So in other words, if the business incurs certain financial liabilities, the creditor can only get to the business assets if they get a judgment against you for those business liabilities. They cannot get to you for your personal assets. They cannot come to your personal monies or your cars or your houses, generally speaking. Now, that brings us back to the purpose of the personal guarantee, and that is to get around that limited liability shield. So, if there are financial obligations that occur under the lease, and they come after the business and they cannot be made whole, the personal guarantee says that you or whoever signs a personal guarantee will personally obligate yourself to cover those business obligations. That basically is an end around the limited liability entity shield that you otherwise have. So the question is, do you really want to sign a document saying that you will personally put yourself on the line or have your spouse or your family members put themselves on the line to cover business liabilities? And do you need to do that? The question of do you need to do that really comes down to one of leverage, and leverage in the marketplace between the landlord and the tenant. What kind of commercial real estate setting do we have? Is the leverage in the area of the landlord, or is the leverage in the area of the tenant? Well, right now we're seeing that commercial real estate is starting to come way down. Some would even call it crashing. And so you would think that the leverage is at least coming more to the side of the tenant. In a situation where, everyone's trying to find a commercial space and inventory is really limited for good commercial space, then the leverage may be on the side of the landlord, in which case the tenant may not have many choices if they really want that space to go ahead and sign the personal guarantee. So some of that deals with the leverage in the marketplace as to whether you have to sign that or not. Now, some of my clients come to me and they say, okay, well, there's a personal guarantee for me in this lease. There's also a personal guarantee for my spouse or another family member to sign. Is it reasonable for them to sign? My take on it is that's not reasonable unless they're directly associated with the business. And one particular concern with having your spouse also sign a guarantee is that now marital assets become exposed to those guarantee obligations as well. So for example, at least in Maryland and many states throughout the country, if you alone would sign a guarantee, then the landlord may be able to get to assets solely held by you. But they cannot get to marital assets, generally speaking, at least in Maryland. They cannot get to, for example, bank accounts held by both husband and wife, or a house if it's titled to both husband and wife. If you have your spouse also sign on though, now that opens up everything that you two hold individually and together. So it's particularly concerning to have your spouse sign on, at least again in Maryland and many other states as well. I recently had a client whose landlord asked for her parents to sign a guarantee. I also think that's particularly dangerous. One, they don't have anything to do with the business, at least in this case. And also, you know, depending on the age of your parents, if your parents are already in retirement, approaching retirement, maybe they're much older and they're on fixed incomes, and they unexpectedly get a bill from the landlord for $200,000 because you had to check out of your lease early, that could ruin your parents' whole financial situation and their ability to continue to live with any means. So it's extremely dangerous in that situation. So you really have to think through and talk to an experienced attorney about what the actual effects of signing these guarantees are before you just go signing away. And make sure that's one, something you have to sign up for, something you want to sign up for, and maybe that's enough to steer you in the direction of another commercial property that is, you know, as appealing or comparable at least, and doesn't ask for such guaranteed obligations. Now, instead of just wholly eradicating the guarantee, another thing that you could do is negotiate the guarantee. So for example, I've had a lot of situations where I've worked for startups, and I can understand the landlord coming to my client saying, look, you haven't been in business for a single day. How do I know that you're going to be good to pay these large lease amounts and take on this financial obligation? And I can understand that coming from the landlord. And in that case, I would, you know, and often do recommend that, okay, sign the guarantee, but make it for 12 or 18 months. Make it for some limited amount of time so that you can show the landlord during that time, look, I'm going to be a good, well-paying tenant, and I will personally guarantee these obligations for a short period of time. And then once you get to know me and trust me, we don't need that guarantee in place anymore. And that's another way to do it if you must have a guarantee in place. Now, I will say for about the period of 2006, 7, 8, 9, 10, when I was getting started with my career, all the way through about 2020, 2021, I never had, it was asked for that my client sign a guarantee, but I never had my client actually sign a guarantee. And the landlord, although they first offered for the tenant to sign the guarantee, they didn't push back on it. Lately, 2021, 2022, we saw more of the leverage flipping in the side of the landlords, at least locally around my office, and the landlords started asking for those guarantees and pushing back and mandating that the guarantees be signed again. And I did have a few clients during that time period that did sign the guarantees, although they were negotiated down. And most recently now, I've seen even more pushing from the landlords in terms of getting full guarantees and other family members to sign guarantees as well. However, I think with the landscape that's developing now, with the state of commercial real estate really falling down, and I think it's going to continue on that trend, I see that the leverage is probably going to push back onto the tenant side in the next year or two or three, and hopefully we can negotiate out some of those guarantees again, or at least reduce those guarantees so that the client isn't personally on the hook for all of those business liabilities that would otherwise be shielded from them by virtue of their limited liability entity. So that's a little bit about personal guarantees, what they're all about, why they're attached to those leases, and what to think about before you should sign. If you liked today's video and you think you got something out of it, please like and subscribe to the channel. It would greatly help my channel, and thank you for joining me again today.